Thank you so much for joining us for this panel. The threat to Delaware and the legislative response. As we all know, the drama that took place in recent months. Several high-profile corporations left Delaware, and then there were two major legislative interventions. One is the addition of Section 122.18, and the other is the amendment of Section 144, overruling certain Delaware cases with the intention of preventing corporations from exiting Delaware to other states, most notably Nevada and Texas. So to discuss the issues raised by the threat to Delaware and the legislative response, we have a wonderful panel. Michal Barzuza is a professor of law and the director of the John Glenn Law and Business Program at the University of Virginia School of Law. She is the leading authority on the incorporation competition between Delaware and Nevada. William Savitt is co-chair and the executive committee and the co-chair of the litigation department of Wachtell, Lipton, Rosen, and Katz. He is a renowned defense lawyer who has litigated many landmark cases. Edward Rock is the Martin Lipton Professor of Law and the co-director of the Institute for Corporate Governance and Finance at NYU School of Law. He is a leading scholar in corporate law and governance and serves as the reporter for the ALI Restatement of the Law of Corporate Governance. Jeroen van Kwawegen, I practiced on spelling the name. On pronouncing the name.
It was amazing.
All right, great. He's a member of Bernstein, Litovich, Berger, and Grossman's executive committee. He is a renowned plaintiff lawyer and a leading shareholder rights attorney nationwide who has litigated and won many famous Delaware cases. Please join me in welcoming our panel. So let me start with you, Michal. Does Nevada pose a threat to Delaware?
Wonderful, thank you, and wonderful being here. So I think the first answer is we don't know. And the reason why we don't know, it's because we have a combination that hasn't happened before. A combination of some backlash against Delaware on the one hand, with a line of cases that some of them might be more scrutinizing than before. And at the same time, also a state that is offering another alternative, which is highly certain because it really bars litigation almost completely. And I think it's the same time that we have this combination. The last time that there was a serious backlash against Delaware was mid-80s. The Interco case, and then was reversed by Paramount. But back then, Nevada was still not such an outlier. So I think the question is really what's on the table is how much bars from liability that are certain really constitute a competition to some inevitable level of uncertainty maybe that arises in a common law system. And first, it's important to understand what the benchmark of Nevada is and how much bars from liability. So Nevada first has been directed since 1987 when it adopted its exculpation statute with a clear intention that is reflected in its legislative history, in its legislative amendments, and in the cases and how judges apply them, with a goal to produce a system that provides more protections from liability than Delaware does. It's that simple. This was when the rules were offered and designed, there were merely no discussions of what is the right balance. The discussions were, this is going to provide more protection than Delaware from liability. Second, Nevada exculpation statute is different from all other states. You have to show intentional misconduct, fraud, or knowing violation of law in order to pass the motion to dismiss stage. Nevada courts interpreted that as requiring showing intention of wrongfulness and knowledge that the law is requiring such and such. And lastly, you have to show all of that with no inspection rights for publicly traded companies, zero inspection rights for publicly traded companies, which is close to impossible. So people tend to bring Wynn Resort as an example of liability. Wynn Resort is an outlier, and the reason why it passed the motion to dismiss was because there was a fight between Steve Wynn and Elaine Wynn, and the whole information from inside the company was in the newspapers, and therefore the plaintiff shareholders were able to bring the facts that were required. But this is really not an example to anything. So in the past, David Smith and I found that Nevada attracts particular firms, problematic firms, firms that have high restatements. Now we see that it's also controlling shareholders. And I think that the problem, on top of all of that, the problem for Delaware is that responses from Delaware actually could backfire to some extent. So for example, SB 21, could maybe reduce some of the motivation to leave Delaware, but at the same time might facilitate reincorporations. Why? Because currently the index funds, for example, have in their voting guidelines for reincorporation. And according to these guidelines, they approve reincorporations depending on the differences between the law in the states and the differences between protection to shareholders. So, so far, they were reluctant to approve reincorporations to Nevada. Because of that, in the TripAdvisor case, for example, if you know, the majority for reincorporation was really relying on the votes by the controlling shareholders. The other shareholders, only 5% supported the move. But now one could make the argument that the differences between Nevada law and Delaware law are not as large as they have been before. And, you know, at some point, this argument might gain some force. So the problem is that the equilibrium is fragile. If Delaware responds, on the one hand, it maybe reduces the motivation to leave, but on the other hand, it also facilitates or releases some of the impediments for leaving to begin with.
So is the solution an opt-in legislation?
Yeah, I think, you know, I was in favor of the opt-in solution. However, I think that the way Delaware responded to the opt-in proposal reflects the level of risk aversion. So whether or not there is a risk to Delaware, I think Delaware officials are highly risk averse, and you could explain that by the characteristics of this market, and it's a network externalities market, and when everyone leaves, it's no, you don't look back and so forth. But I think their response was, we don't want firms even to get to this decision. Once they start thinking, do we want an opt-in mechanism that you have to vote into and so forth, they might as well decide, okay, so let's then reincorporate because it's very similar, and then we get all of the protections and we don't have to decide about it, to think about it more. So from what I've seen from Delaware officials' response to that, I think this is also reflective of their high level of risk aversion.
And should we expect that next we will start seeing negative price reaction to companies moving to Nevada, given the description you gave on what's going on there?
Yeah, I think that it's very difficult to measure the effects of law with our tools. And I think that, you know, event study of moving to Nevada, there are lots of difficulties with it. And even if we manage to do that, all it reflects is what the market now predicts going to be the effect on firms, which the market also doesn't have an experience with this type of firms being incorporated under this law. And of course, there's the question of, does the market already incorporate this knowledge after TripAdvisor and make some predictions about companies leaving and so forth? But I think that, you know, what we have to ask ourselves is, what do we think about our corporate law? If we believe that the common law system had value, that our fiduciary duties have value, then we ought to think that something is going to change under a regime that is very certain, does not require almost judicial expertise, because it's a very narrow category of liability that is not about fiduciary duties even, intentional misconduct, fraud, or non-violation of law. That does not have a unical and Revlon because they're replaced by the business judgment rule, that does not have entire fairness, and that has close to a complete bias for litigation. So if we do believe that our fiduciary duties and standards had some values, then these values will be affected. I don't think it's going to be easy to measure it by event studies.
Thank you, Michal. Ed, so what is creating the pressure on Delaware doctrines specifically now?
So I don't know. I've been watching what's been going on for the last year and a half with a certain amount of puzzlement. Dexit strikes me as particularly puzzling. It inspired me to learn a little bit more about Nevada corporate law and Texas corporate law. Texas corporate law, of course, I mainly knew through the Pennzoil Texaco litigation, which remains, it seems to me, a very strong reason why no normal public company would want to reincorporate in Texas. Texas has in its state constitution the right to a jury trial. And so being able legislatively, as Texas is moving in a direction to eliminate jury trials in corporate matters is quite questionable and may require a constitutional amendment. Trying to learn about Nevada corporate law has also been difficult because while it's easy to find the statute, it's really hard to find any trial level opinions because they don't really publish their trial level opinions. So trying to figure out who the leading judges are and how good they are as judges, to me as an academic, is almost an impossible task. So I start by thinking that for a normal public company with dispersed ownership, the idea of reincorporating out of Delaware into Texas or Nevada is like insane. If you're Tesla, which is not a normal public company, Tesla, it makes perfect sense to go to Texas in the same way that if you were the Pennsylvania Railroad in the period after the Civil War, you wanted to be in Pennsylvania because you owned the legislature. And if you were the New York Central in New York and during the same period, you wanted to be in New York. So if you go back historically and look at the battle over Erie Railroad, you'll see that it was a battle between the Pennsylvania Railroad, which controlled the Pennsylvania legislature, and the New York Central that controlled the New York legislature. And Tesla has I think a reason, by being one of the largest employers in Texas, has a reasonable basis for thinking that they'll get treated very well in Texas. But for a company without the peculiarities of Tesla and without a controlling shareholder who can, as an TripAdvisor, vote for the reincorporation, it strikes me as quite implausible. So the question is, what's going on? This is really, and as I say, I don't know. There seem to me to be two non-exclusive hypotheses, both triggered by the same rage tweets by Elon Musk. I think the rage tweeting clearly is what triggered this, maybe combined with Musk's position in the Trump administration. One version is that it incited a concern among small minority controllers in Silicon Valley. The folks who have control by virtue of dual class capital structure have control with 9–10% of the cash flows, but in excess of 50% of the votes. Now, from the time I've spent out in California at conferences and chatting and so forth, the role of Delaware corporate law in California is different than it is in New York or on the East Coast. Delaware is really far from Silicon Valley in all sorts of different ways. It's far geographically, it's far psychologically. The idea for a dual class company with a controller that some judge sitting in Delaware is going to tell him or her that you can't do something is kind of intrinsically implausible. Like, who's that guy? How does he get to tell me what to do? So I think there's one plausible story is that the Musk tweeting got a bunch of controllers in Silicon Valley companies asking themselves, what do we want with Delaware? And they, of course, all come with law firms. And so they call up their law firms saying, well, what's going on in Delaware? Why do we really want to be in Delaware? Maybe we should find someplace else. And of course, on this story, once you start calling up your lawyers, they start calling the lawyers in Wilmington saying, what's going on out there? And you're in real threat of losing your franchise. So that's one story. There's a second hypothesis, which is that the same tweets triggered the opportunity to perhaps overblow a bit the prospect of Dexit in order to implement some changes that the people pushing for them genuinely and sincerely believe should be made to Delaware corporate law. So the corporate law equivalent to Plan 2025 that was talked about in the election, the corporate law equivalent is the article that my friends Larry Hamermash, Leo Strine, and Jack Jacobs published in the Business Lawyer. Form over function at 20, I think is what it's called. And it is their view of all the things that have gone wrong in Delaware law since Leo Strine retired as Chief Justice of the Delaware Supreme Court. And there are a lot of interesting ideas there. It's a great article. The alternatives analysis is that, as Rahm Emanuel said, a crisis is a terrible thing to waste, and that this crisis was ginned up because people were convinced that Leo and Jack and Larry's suggestions in that article should be turned into law, and this was an opportunity to do so. Now, I don't know which is the right answer as to what actually happened. It could be both, but the success of this effort to change Delaware law, the success of this effort inevitably says to those small minority controllers in Silicon Valley that Delaware listens to them. Now that's important. The notion that Delaware listens to them is important to stem even the possibility of serious Dexit. On the other hand, the problem it creates, and this is my genuine worry, the problem it creates is I don't think SB 21 does very much to change Delaware law, and particularly, it doesn't do anything to meet the concerns of a small minority Silicon Valley controller about these judges sitting in Wilmington telling him or her what to do. And here's the problem. The problem is, as Kobe Castiel and Lucian Bebchuk taught us in a really marvelous article about dual-class controllers called the Perils of Small Minority Controllers. If you are a 10% equity holder with a majority of the votes in a company in Silicon Valley, you have an increased incentive to take side payments, to take private benefits of control, compared, for instance, to a traditional controller. So Bill Gates controlled Microsoft as CEO. As CEO, he never took more than $675,000 a year in compensation. Why? Why didn't Bill Gates take more than that? And the answer, of course, is he owned half the company. Bill Gates limiting himself to $675,000 meant that other executives couldn't get outsized compensation, that all of the employees understood that Bill Gates's interests, his incentives were strongly aligned with building the value of Microsoft. And therefore, what did he need to take excessive compensation? But if you're, to take one example, take Trade Desk. If you're Jeff Green at Trade Desk, you have 9.5% or so of the equity, but you have 50% of the votes or 55% of the votes. Now, for excessive compensation, you only bear 10% of the cost. But you view your contribution to the company as huge. So that taking large compensation is a sort of contingent recapitalization of the company. Now, when I first read Lucian and Kobe's article, I said to myself, well, I understand the argument that they have an increased incentive to take side payments. But Delaware does a really good job controlling related party transactions. Delaware judges are really sensitive to conflict of interest transactions, so I don't have to worry about this increased incentive. What I've learned from the battle over SB 21 is not only do small minority controllers have an increased incentive to take private benefits of control, they equally have an increased incentive to dilute the controls, the laws that limit taking private benefits of control, that they bump up against the limits and they say, this is crazy. Let's put pressure on Delaware to dilute what has always been, in my mind, Delaware's greatest contribution to corporate law, which is the control over conflict of interest transactions. And if that's true, then what I worry about is that once they discover that SB 21 doesn't do very much to protect them against being second-guessed by smart, knowledgeable, independent Delaware judges, they're going to come back and ask for more. Let me stop there.
So if Nevada and Texas are not a threat, so we have here the legendary Mark Rowe sitting at the end. So let me ask you, what about the federal government?
I think the federal government is and has always been the major threat to Delaware's incorporation business for many of the reasons that Mark has given. That a nightmare coalition between, say, Elon Musk and my old Penn colleague Elizabeth Warren could eliminate Delaware's role in corporate law tomorrow. Because there's no doubt that under the Commerce Clause, Congress has the power to nationalize corporate law. And it wouldn't take very much for Congress to say to the SEC, you take the lead on this, provide minimum standards of investor protection for both public and private companies. I think it would take a legislative change to expand it to private companies. But it seems to me that that is the threat. It could easily be done. And frankly, watching Delaware lawmaking over the last 15 months, I don't think it withstands scrutiny. I don't think it's the kind of process that one expects for lawmaking for the whole country. That the testimony in front of in the Delaware legislature, the way my NYU friend, colleague, and co-director Rob Jackson was basically shut down as he tried to testify on the value of an opt-out provision. I don't think Delaware can look at that and say, this is the kind of lawmaking you need for national corporate law. And I think unless Delaware ups its game in terms of the quality of its lawmaking, it sets the stage for what Mark has discussed in terms of federal intervention.
Thank you, Ed. Bill, is there a real risk that Delaware would lose its franchise?
Thank you for the question, Zohar, and thanks for the opportunity to be here. It's always good to be back at the law school. I think the answer is yes. I know that there has been some skepticism whether the threat to the franchise is real, whether, in fact, a critical mass of Delaware chartered firms would, in fact, exit. And I think that skepticism is misplaced. To be clear, my view isn't that there is certainly going to be a stampede. My view is that there is a real risk of that. And that view is informed by interactions with clients and prospective clients in respect precisely of this issue. I looked at the data for the year to date, and about 18 established firms have left the jurisdiction in the first couple months of this year. That's not a lot, and some of them were controlled companies. Not that many have left. We don't know how many firms have incorporated under the law of other states that might have incorporated under Delaware law, but I don't think that really gets at the risk. I think the risk is more that one could see a firm or two of a respectable character deciding to reincorporate and create cover for many, many, many others who might be inclined to do so. It's a little bit like the Hemingway law of motion, in which someone was asked, how did you go bankrupt? And the answer was very, very slowly and then all at once. And I think that's what one could imagine here. A vast exodus very quickly. And I don't think Delaware is going to lose an important place in the corporate law ecosystem. The question is whether it will become a competitive environment. Delaware doesn't really want a competition for charters. It wants to be a quasi-monopolist, and I'm actually with Delaware on that. That's my personal preference, and I think it's probably the optimizing preference. But the following is true. Lots of people who run companies, CEOs, general counsel, chairs of boards, are calling their lawyers and saying, should we leave? Many are calling and saying, I'd like a presentation whether we should leave. Some are calling and saying, I'd like a presentation directing that we leave. This is happening. This isn't lawyer driven. It's not professor driven. It's executive driven. And it's some controlling companies, but it's not just controlling companies. And I think the risk is real to the franchise, and I don't think it is extremely surprising. One thing that I think is missed in this discussion, and I think is worth observing, is that part of what's created the turbulence in this market isn't the substance so much as the surprise. There have been some decisions from Delaware, and I'm not here to debate whether they're right or they're wrong. That's kind of neither here nor there, and it's not productive, but they just surprised people. We represented Moelis, and there was the decision respecting the viability of its stockholders agreement. We argued that. Vice Chancellor Laster issued his opinion. And I'm not exaggerating when my phone rang off the hook for the days after that. Company after company after company called and said, what in the hell is going on? What's going on? Forget whether it was right or wrong. They didn't know what to make of it. It seemed off the wall. Off the wall. It surprised people. It did. And that's not to argue against the opinion or for the opinion. Court is the place for that, not this venue. It just surprised people. And it also raised the question, well, what about this agreement and that agreement? What about my credit instruments? What about my indentures? What's going on? Why did they do that? No one thought this was going to be the outcome. For 40 years we've been doing this. What's going on? The Activision decision had the same effect here again, not to quarrel about the right or wrong of it. It surprised people. And it undermined the reliability in the minds of some, at any rate, that Delaware had cultivated. There's also this interesting way that corporate leaders talk about judges, and it is picking up on a thread that Ed started to unspool. It's more common talking with folks on the West Coast than the East Coast about, and I would use air quotes if I was inclined, activist judges. I never thought of activist judges as corporate law judges. That seemed to be a whole sort of branch of judicial thinking, but activist judges, and what's being discussed there are judges who arrogate to themselves the authority to determine corporate questions, just in the way I think that Ed was talking about. Who are those guys to be telling me what to do? What's interesting about it is that the issue isn't just under what circumstances do judges get to make the decision. The issue is under what circumstances will there be deference to other stakeholders. And I think there had been an apparent equilibrium in the middle of the 2010s when you look at Corwin and MFW about under the circumstances under which there would be deference to management decisions, and then the extent to which there would be deference to stockholder decisions, and then the extent to which there would be decisions that required an even higher level of scrutiny. That surprised people, the way that law has developed. And I think that's a very significant piece of the puzzle, the idea of reliability and surprise, predictability and surprise. I agree with Ed that SB 21 doesn't actually get at the real problem. It doesn't get at the real issue, and I don't know that it's really likely to solve the problem. I also agree with the sentiment that a flight from Delaware to Nevada or Texas is not a good thing. My advice to clients nearly uniformly is don't do it. There will be adjustments made in Delaware law when it's necessary, and at the end of it, it's a terrific bench and a terrific set of law with generations of common law behind it, and it's better there than a step into the unknown. I think that will be ultimately where it lands, but I can't say that there isn't very substantial risk of a stampede. I think there is. And a final thing to observe is that there's a great article, and it's not new anymore, about saints and sinners in Delaware law. Just a great article. You got to read it. But the thing is,
Certainly not new anymore.
yeah. But the thing about it is it really gets at something fundamental in Delaware. People, though, one thing to note is people actually don't like being called sinners, and they don't love it when they are hung high from the tree branch. And there is a lot of anger about the demonization that some people in corporate America think is coming from the Delaware Court of Chancery. And here again, I'm not here to take sides on it. I can tell you these are the things that we hear. And these are the things that create some risk to the franchise. And I think it is a real risk, though I don't think it's an irreversible risk.
So if we can get a bit deeper than just the phone calls. So what's on the phone calls? What specifically in Delaware is so different that companies would like to go to another state? What are the reasons that companies voice to you, or you as a lawyer feel it's different in the procedure, in the evidence, in the standard of reviews? Where is that?
A couple of things. One is that I think there is a sense, as I said, that the judges in Delaware are much more comfortable substituting their views for the views of boards of directors, management, and stockholders. Much more comfortable doing that. And they probably are, and they are because they are more expert. But if you're of the view that in general, the decisions of managers, and in some cases managers and boards, and in some cases managers and boards and stockholders ought to be deferred to, then a regime that declines to defer to them more frequently than others is one that would be, relatively speaking, unattractive. A second is that there are species of liability that Delaware has sponsored that do not exist as clearly in other jurisdictions. For example, since the ice cream case, the Marchand case, there has been a very significant increase in caremark liability in Delaware and not outside of Delaware. Claims are being sustained at a rate of 1 in 3 as opposed to 1 in 100. And these claims typically take on great settlement value once they are sustained. People have taken notice of this. That appears to be a theory of liability that has great traction in the courts of Delaware, but much less so elsewhere. And whereas finally, I think there had been a historical presumption that a Delaware court would be more likely than another court in a complex commercial matter to look at it on the pleadings and dismiss it, recognizing the enormous value that a case obtains merely by withstanding a motion to dismiss. That presumption no longer applies. Delaware is now one of the few states, to put it in doctrinal terms, that maintains the conceivability standard, whereas nearly the rest of the country has followed the federal courts to a plausibility standard, and that carries through. The ratio of dismissals has declined in Delaware, and the expectation of dismissals has declined in Delaware. So rather than having a competitive advantage in that respect, it is neutral at best. I think these are the things that are animating folks to develop their concerns.
So it sounds like the fear is from judicial interpretation of the scope of liability. So what's the solution for that?
I think the solution is, look, for as long as I've been practicing law, and even before then, when I was studying in this law school, Delaware has been the corporate law of default choice. I understand that before then, my senior partner, Marty Lipton, decided that he was going to say maybe everyone should leave Delaware, and there was a course correction in respect of the Interco decision. This is what, 1990, something like that. I think it is a characteristic of Delaware law, as most branches of law, as most branches of civilization, to have pendulum-like swings of emphasis in a spectrum of outcomes. I am confident that if firms stay the course and lawyers give good advice, Delaware will find an appropriate equilibrium. I worry that the aggressive attitude of certain anti-Delaware people, and we've talked about the Tesla companies and their affiliates, is going to create an opportunity for flight. All I can say is everyone, companies, lawyers, Delaware lawyers, national lawyers, New York lawyers, Los Angeles lawyers, and all the judges need to be attentive to the need to find the zone of consensus, not the zone of consensus for a particular outcome in a particular case, but what the tolerances are for a corporate law that works. And I do think no one likes surprises, and that's something to keep in mind.
Thank you, Bill. Jeroen? So is SB 21 part of a race to the bottom?
So, does this work? Can I take yours? Oh, thank you, Zohar. This is working now? Okay. Thanks, Zohar. So, before I answer that question, I do want to respond to a few things that Bill said. And before I do that, I want to make some preliminary comments. First, thank you for inviting me. I really appreciate it. It's always great to be back at Columbia Law School, where I went to law school about 25 years ago. I was teaching at Harvard last week, and I told them they have nothing on Columbia. They don't like it. It's a fine school, but this is the school. Okay, let me start with that. Second, as you probably heard from Zohar's intro, I represent shareholders. And I think that that's important for you to know, because that's the lens through which I look at the world. Okay. Bill, my friend on the other side, represents boards of directors. We have many cases together. He's always on one side. I'm always on the other. I have great respect for Bill. And I say all that because I disagree with every single word he just said. And I'll explain why. Finally, you should also know that I have a case against a certain Doge representative called Elon Musk. That's right now on appeal. We took away his compensation, and he was very upset about that. I'm not. And I'm saying that because I also want you to know that these views that I'm expressing here are my personal views, not the views of my partners, not the views of my clients. I'm not going to talk about that case, but these are my personal views. All right. So Professor Rock talked about the two reasons for SB 21, and I think he's right on both. And the way I would describe it is, this was a hissy fit, from a certain shareholder of a certain company that later moved to Texas. But that was in January of 2024 when we won our case. Pissy fit. Two, there was an opportunity created. And the opportunity that was created was the election of a new governor of Delaware. Inexperienced, didn't know what he was doing, immediately went public and said, we need to help people like Elon Musk and people like him. This is in the Business Insider. He goes on TV. And then, yes, there was this article that Professor Rock mentioned about optimizing Delaware law, which was then used as a template to change Delaware law through SB 21. But it went much further than that. I'll get back to that. One of the things that Bill just said that I fundamentally disagree with is that this was not lawyer-driven. It was absolutely lawyer-driven. It was absolutely Wilson Sonsini lawyer-driven. Look at the timeline. January of 2024, Musk loses, starts tweeting his things. March 2024, Match comes out in a way that was not necessarily the way defense lawyers had predicted it would come out, right? MFW applies to all controller transactions, shorthand, okay? April 2024, go on the Wilson Sonsini website. Should companies be asking the question whether they should stay in Delaware? What? This is Delaware Wilson Sonsini, but Wilson Sonsini, we all know, is a Silicon Valley firm. Same clients that we talked about before. And so, of course, people start asking questions. And you know what? When I was at Latham & Watkins a long time ago, I got questions all the time. What matters is not whether questions are asked. What matters is what answers are given. So this whole idea that this brewing Dexit, in my view, is entirely lawyer-driven because Elon Musk created the opportunity together with the new governor, and Match did not come out the right way for the defendants. So they start talking about like, oh, you know, there may be a lot of companies leaving. We're talking about a stampede. We're talking about Dexit. Here is the data, okay? There are about 2,700 public companies incorporated in Delaware. 2,700 or so, okay? Rounding. And Delaware is a volume business. The franchise taxes for the state are capped, $250,000. So if Meta leaves, that's $250,000. If XYZ company that you don't know about leaves, that's $250,000, assuming a certain size. Still now, 80% of all IPOs are of Delaware companies. Didn't change since Elon Musk started tweeting in January 2024, please leave. And every single year over the last 10 years, 10 to 15 companies reincorporate from another state to Delaware, and 10 to 15 companies reincorporate from Delaware to another state. And when you look at the proxy statements and ask, well, why did they leave or why did they come until SB 21? The answers were really clear. The companies that left uniformly said in their proxy statements, we should leave because the franchise taxes are too high. The $250,000 is too high. So relatively small companies, Tesla excluded. And if you looked at the proxy statements and said, well, why are they coming, these 10 or 15 every year? Uniformly say the quality of the judiciary and the courts. That did not change after Musk lost his compensation package. Companies understood, boards of directors understood that moving to Delaware came with the quality of the judiciary. Now, Bill has talked a little bit about unpredictability. What I call that is sore losers, okay? Sometimes you just don't win. Everybody loves accountability, but not for themselves, okay? But when you think about the cases that I prosecute, and I have many of them in Delaware, I lose more than I win, okay? Because the Delaware courts have always been very protective of boards of directors. I can give you ample examples. But sometimes it's part of a normal judicial system. The defendants lose. And if you can't take that, yeah, then you go to Nevada. So we talked about Nevada being a threat, okay? Nevada was never a threat. It was always out there marketing itself as the anti-Delaware. People were not leaving for Delaware, for Nevada, because it didn't come with the quality judiciary. Quick side story. I had a case in Nevada at one point, and the judge overseeing that case, this is one of those specialized business courts that Zohar may be talking about later. The judge overseeing that case, during the case, came around with hat in hand, asking for contributions to the re-election campaign. No joke. No joke. Okay. And so really, that's the kind of legal system that you want to move to and reincorporate to? The other thing also, and I think this is a really important thing. So Bill was like, talking about this the potential stampede and everybody's leaving. That is subject to a stockholder vote. Okay, you can't just leave. And every year in the last 10 years, a couple of companies that were not controlled said, we will leave. And then the stockholders said, nah, no thanks. We kind of like it here. And so they wouldn't leave. So I've always said, and I continue to say, that this idea of a Dexit has been wildly overblown to give cover to make changes in the law that would benefit controllers. So very quick example on that, and this is about the race to the bottom. Okay, as you can see from my name, and thanks again for pronouncing it correctly, I'm from the Netherlands. And the way I saw Delaware for a very long time was like, that little child with the finger in the dike, holding the water back. And the other side were the controllers and the people who don't like accountability for themselves, saying, we need to change, we need to change, we need to change. And that finger is now out of the dike. And we have a race to the bottom. It wasn't there before, but it is there now. I recommend this article from Professor Hurt. It's called Texas, Delaware, and the New Controller Primacy. It just came out. Very interesting article. And she's talking about how this professor from SMU, she talks about how what we're effectively seeing is a system moving from shareholder primacy to a system of controller primacy. And I think that she's right. I'll give you one example under SB 21. So under SB 21, creates a bunch of safe harbors. And one of the safe harbors that it creates is this idea that unless you have at least 33 1/3% voting control, you cannot be a controller, and therefore you have no fiduciary duties, right? It's basically a threshold. Now think about a typical Silicon Valley company, right? It starts in Silicon Valley. It's like funded with venture capital. As venture capitalists do, and smartly so, they put all kinds of protections in place and agreements in place to make sure that the venture capitalist that puts in all the money in this very risky venture retains control over the operations of the company, retains control over the CEO and the board. Normal, all normal. Company then goes through a couple of rounds of financing, the agreements stay in place, it moves to Delaware, and now it goes public. Venture capitalist has already cashed out with the IPO, but the agreements stay in place, and there's still a significant controller. They now start selling down. They go below the 33 1/3%, but that controller still has all those agreements in place. Who the CEO may be, key supplier contracts, but under this new law, this controlling stockholder owes no fiduciary duty, controls all the companies. And then going back to the dual class example that Professor Rock just gave, company has a great year. What prevents that controlling stockholder, although not a controlling stockholder under the law, but effectively controlling the company, what prevents that controlling stockholder from saying, it's been a great year, I'd like a little side payment. Give me $100 million, management contract. And the answer may be, the company can say no. Well, actually, no, because they control the board and they control the CEO and they control the supply contract. So that basically puts the company in bankruptcy. Okay, now they say yes. Okay, what about the 70 or 80% public shareholders? Can they do something? So I am actually much less sanguine about the ability of the courts to actually impose some accountability on this scenario. And actually, when you think about all the provisions of SB 21, it creates a situation where controllers are incentivized to structure transactions in a way to fall within one of those safe harbors and then say, judge, you're an activist, stay out of this. Whereas what in fact should be happening is the judge should be managing the agency costs and make sure that all stakeholders are represented, not just the controller. So I'm very nervous about this. And what you now see is Delaware has gone down in protection of shareholders. And what do Nevada do and what does Texas do? They're tripping over themselves to go even more down and say, well, even less shareholder protection. And so I'm concerned about the long-term effects of this on the health of our public markets. and the health of investors, because look, I represent a lot of European investors, right? I have a couple of roles at my firm. And the number one question I get is the US still investable? Not just because of Trump, but also because of things like SB 21, right? If I invest in a Delaware company, are people just going to be taking advantage of me, and maybe I should be investing somewhere else? Not necessarily in the United States, because capital is fungible. It can go anywhere. So I'm very nervous about this. I don't really know what's going to happen. Final note on Texas. I love jury trials. Do. I also like jurisdictions that don't have a lot of experience. You know why? Because if I have a case in Texas, I will find a judge's cousin, and he will be my local. Okay? There's a lot of value in having expert judiciary that is not beholden to anyone. And you know what? When I look at Delaware, you can always nitpick on particular judges. Okay, you can say, you can analyze this judge, and you can analyze this judge, and da-da. But you know what? I don't have to be worried, as a New York lawyer, which Bill is too, as a New York, I don't have to be worried that I get some hometown effect, or that I need to find a judge's cousin to have a chance in court. And you know what? I tell all my clients that. The largest asset managers and hedge funds and pension funds in the world, I say, look, there's value in having an actual independent judiciary that you can have faith in. And what I'm most concerned about with this whole SB 121 conversation is the veiled attacks on the judges in Delaware who are just public servants and are trying to do the right thing, whether they rule for me or against me. And I'm really, really concerned, because that's what made Delaware special, and that's what's going away. And as you look at, I don't know if anybody read the CalPERS letter that was filed in connection with SB 21. And CalPERS said, look, if you do this, why should we vote against reincorporating outside of Delaware? I can't really disagree with CalPERS on this.
Thank you, Jeroen. I guess I have a different perspective on this tension that we are discussing here. In a new article just uploaded to SSRN together with Professor Thomas Stein, the article is titled "Live in Delaware: The Essential Role of Specialized Corporate Courts." And we start to understand this problem by asking the crucial question. Everyone says Delaware has a specialized court, but what's the core competence of a specialized court? What is that we are looking when we are thinking about the uniqueness of a specialized court in corporate law? And our answer, which might sound provocative, but I hope that after you read the paper, that you will be persuaded. Our answer is that the core competence is claim dismissal. The courts specialize in dismissing cases, which sounds weird, but we believe that's the core competence, because basically you have a universe of cases, and the first cut is between cases that are mismanagement cases and cases that are conflict cases. And the court needs to dismiss all these mismanagement cases and leave the market and the shareholders to deal with those cases on its own without letting that go through litigation. The other pile, which is the conflict cases, so their shareholders have much less ability to handle on their own issues of conflict of cases, and the expertise of the judge is required to get into these cases, intervene, provide remedies, and protect shareholders from expropriation. But the difficulty is that even among those cases, the conflict cases, there is subclass of cases in which the court should also dismiss, much like the mismanagement cases. And making that distinction is very hard. This is where expert judges are prone to make mistakes. Why? Because I'm an expert. My intervention is normally required in conflict cases. If I'm going to say that this class of cases is dismissed, then all future cases like that, I will not be able to say anything. I will not be able even to hear what happened, okay, because I'm given a motion to dismiss. Therefore, I should keep at least an eye by having all these cases that involve conflict under my jurisdiction. And when they do that, this is where they miss their role at claim dismissals. So we can take the duty of care cases. Smith versus Van Gorkum. Smith versus Van Gorkum is a duty of care, which should have been dismissed. But Van Gorkum had conflict. He was close to retirement. And the notion was that this transaction of selling the company was rushed in order to accommodate the personal interests of Van Gorkum. So the court, in order to have jurisdiction and there is conflict and provide some remedy, raised the bar of the standard of review. Okay, so then come the legislator and say, okay, that's just too much. We want to bring it back. And this is how you get 102B7. What happened with SB 21? Similar process that took much longer, not a single decision. But over the recent years, Delaware expanded the definition of what is a controlling owner, okay? They expanded the decision of what is self-dealing. They expanded the requirement for cleansing, that you would need the dual requirement for every self-dealing and not just for freeze-out. And that created a universe in which claim dismissal is very hard to achieve. It's even very hard to comply with MFW, even when you try. It's like 4 out of 15 cases managed to do that. So this is the place where the legislator come back again and say, okay, I want to refocus. I want to refocus the judges back to the main competence of claim dismissal, and they give the definition that Jeroen doesn't like by limiting who is a controller. They minimize the requirement for cleansing for one cleansing mechanism for all self-dealing and keeping the two just for the freeze-out. I still think that they should have also minimized the scope of self-dealing. I still think it's too broad the way it is now in Delaware, but that's for a different project. All right, so before I open the floor for questions, Ed would like to respond to Bill, so please.
We're not ganging up on you.
No. So I want to expand on. So Bill makes the point that he's in favor of Delaware maintaining its monopoly on corporate law. And I think that's a really interesting comment and a really interesting insight that we should think a bit more about. Because I basically agree with him, though it does seem to me that innovation from other states is welcome. But if we think back to corporate governance over a broader period, the New York Stock Exchange used to be a critically important source of corporate governance standards. And it could only do that when it had a monopoly as a stock exchange. As the stock exchange business has become competitive, the New York Stock Exchange lost its ability to impose significant corporate governance standards on listed companies. And to the point where today it's so easy. If you don't like the New York Stock Exchange standards, you can go to NASDAQ, you can go to Hong Kong, you can go to London. There are lots of opportunities. And that's a deep insight. The question Bill raises is connected to that in another way, which is he says that Moelis was a surprise. That however you come out on the merits of Moelis, it was a surprise. And the question is, if so, why? I had an interesting conversation with a now retired experienced Delaware lawyer. We were talking about Moelis, and he shared my view, which is the Moelis agreement itself was so obviously inconsistent with the standard Delaware interpretation of 141A that it was really hard to see how a lawyer ended up drafting it. And his view was, because I don't have his permission to pass it along, I'm not going to name him. His view was that something's broken down, that in the old days, as a senior member of the Delaware Bar, he would get calls from people saying, we're thinking about doing this. Does this comply with Delaware law? And he'd often say to people, no, this is why it doesn't comply. And that a an agreement like the Moelis stockholders agreement. In the old days, somebody would have called the standard lawyer they use in Delaware and say, what is it? But that doesn't seem to be happening anymore. Now, why doesn't it happen? I think one explanation goes to this question of monopoly, and that's why I connect the two, which is there are many, many more Delaware firms now that have significant practices. It used to be there were just the big four who sort of had a monopoly, a shared monopoly in the old antitrust term. And now you've got a bunch of outside of Delaware firms that now have big Delaware offices and big Delaware practices. And you combine that with the psychological difference of Silicon Valley being far from Delaware in the ways that we've discussed. And I think there's less consultation now with Delaware lawyers about things like the Moelis agreement. And that likewise, just as the competition has diluted the New York Stock Exchange's ability to impose corporate governance standards, that likewise has had an effect on how Delaware firms are able, through the consultation process, to uphold Delaware standards, and that's made it more difficult, so that surprises are more likely the less consultation there is with the Delaware firms.
Questions? Please.
Yeah. I think that we wouldn't be here talking about this were it not for Elon Musk and kind of, not getting his way and saying,
Could you please introduce yourself?
Oh, yeah. Doug Cha from Rutgers Law School. And so, but I think what happened was it opened up an opportunity that was rather unfortunate. I think, was it Jeroen, you were saying that, the shareholders also have a role to play here in protecting this flight from Delaware. What happened in the Tesla vote was that the largest or some of the largest passive investors voted for the redomestication to Texas. And that was what really disappointed me, because even if Vanguard, BlackRock, and T. Rowe Price had voted against the redomestication, that it still would have passed. But what it did is, not only did they vote for it, but they issued papers explaining why. And their explanation was, well, we've read both sets of laws and we think they're about the same. And also we don't think this really affects shareholder rights, going from Delaware to Texas. It's really up to the board to think about that. And I was like, are you kidding me? You're going to trust future decisions about shareholder rights. You're going to leave it up to judges who have not even been named yet at the time in courts that haven't even opened for business. Judges who get reappointed every 2 years by Greg Abbott. And so these, the large institutional investors basically gave permission in the future for investors to vote with any company that's going to leave Delaware. And the question was, wait a second, don't these guys care about corporate governance? They say they do, but clearly they don't. If they're voting with Elon Musk, who's saying, I didn't get my way in Delaware, so I'm going to take my ball and go to Texas. Because I will get my way with the courts there. And so, the question is that, is that going to come into play? Are these, are companies encouraged by the fact that the largest passive investors are on record saying we don't care? And is that going to be a factor, or is it going to be one of these, anything that Elon Musk touches is not a precedent for anything? and we should just ignore, the Tesla vote. I think the Tesla vote, especially since the investors came out and wrote papers saying that we don't care, is a huge factor here. And so I'm not confident about shareholders being the gatekeepers. So I'm just wondering, what you all think.
Thank you. Michal, do you want to take this?
Yeah, great. So I think, I'm with you that they should have taken into account also the quality of the judges. However, it's not that they do not care at all. So they're right that on paper, Texas law is very similar to Delaware law. Texas exculpation statute is like Delaware exculpation statute, and therefore they do not have the same position on reincorporation to Nevada. This is why firms that reincorporate to Nevada don't get support votes from these shareholders so far. And this is also probably part of the reasons Elon Musk opted to Texas eventually, because his initial intention was Nevada. He incorporated X at Nevada. And so I think that I'm with you in the criticism that they should take into account also the judicial quality, but it's not that they do not care at all. They do compare the law, and it's part of their voting policies to make this comparison. And Texas now is making amendments to its law that might change their opinion. Now, the last thing I'll say, though, that 2 days ago, there was another development, which is Fidelity that tried to reincorporate to Nevada last year and was not successful in getting shareholder support and didn't have a sufficiently large controlling shareholder, and now filed a new proxy. And in this proxy, they say that they reached an agreement with their shareholders that they will reincorporate to Nevada, but they're still going to keep Delaware exculpation statute. So in the charter, the exculpation will be like in Delaware, and it's going to be Nevada judges applying Delaware exculpation. So maybe this is something that the funds now are settling on, and I also don't think it's a good result, but this is where we are.
Thank you. Riley?
Bill was talking about these activist judges in Delaware, and this is a critique I've heard from certain other proponents of SB 21 as well, and 2 judges in particular. Of course, there are 7 members of the Court of Chancery. I don't hear these complaints about certain other members of the Court of Chancery, which suggests maybe we have some sort of principal agent problem here, in which there are some kind of rogue agents. And the solution that SB 21 seems to take is you constrain the actions of those agents certain ways. But one other solution would be you change the mechanisms for appointment and retention of those agents, which is not a sort of proposal I've really heard floated much. And I'm wondering why that is. Is this wrong for some sort of reason? Why has the solution been to sort of constrain the actions rather than change the actual appointment mechanisms?
Well, I'm not sure that I'm the best person to answer that question, but I do want to clarify what I said, because I believe I was pretty careful in the words I chose. I was relating what I had heard from clients when I talked about activist judges, not my words, not my view. And I want to be really clear on that. Moreover, it's very important to me, and I've taken care on this. I don't single out a judge, 2 judges, 3 judges, 4 judges. I don't do it. I've never done it. I won't do it. And I will, although I was a little bit bewildered by certain of Jeroen's attacks on my position. I will agree with him really vigorously on this. All of the judges on that court are incredibly hardworking people who are doing everything they can to get it right, and they're smart and they're very good. And I don't want anything I've said to be misconstrued as contrary to that. I do think it's true that one could look at the problem as focused on the personnel rather than the law. I mean, the system in Delaware is the system in Delaware is not that unusual, however, and it's not been a point of focus for me. So I haven't really answered the question, but I did want to make sure to clarify that.
So I personally think that the analogy to rogue agents is a very, very good one, because it says something about the mindset of the proposed principle. There's a sense of entitlement and arrogance on the side of the corporate defendants that sees these judges as they have to rule for me, and otherwise they are activist and rogue. Because when I lose cases, I lost BGC, look it up. egregious facts. I lost. It was affirmed on appeal. Was I happy about it? No, absolutely not. Hurts to this day. But did I go around the country and say, you know, we have an activist judge who actually doesn't care what the special committee makeup is. And it's all totally fine if the head of the committee says, you know, if the controller wants to skim a little bit off the top, why would I care? Right? Did I go around the country and attack that judge? No, because I believe that we have to accept judicial outcomes and accept that they come from a place of good faith. But the principles in your analogy don't accept that when they lose. And that's a big part of the problem. There's like an Overton window shift where now it's okay to criticize judges who hold people accountable.
Andrew Shapiro, Lawndale Capital. Two questions for the panelists. One is, do you have any comments or thoughts about the Dropbox case and the assertions that certain SB 21 amendments violate the Delaware Constitution and thus are unconstitutional by barring in many ways any equitable protections for certain questionable behaviors? And the other question, a little bit of field here, are there issues of concern for truly independent directors who want to make sure their fellow board members behave appropriately? Are there concerns for truly independent directors of moving to a more permissive incorporation state like a Nevada?
Khan, do you want to take this?
So I'm not sure I completely understand the question. Concern for the independent directors?
Well, if you're an independent director,
You are less concerned in Nevada because you're not going to be sued. It's almost impossible to sue.
I understand that, but I've
Yes.
served on public company boards, and when you're in a public company board, there's a range of views in that boardroom.
Right.
You want that board as a whole to behave within
Yes.
guardrails.
No, I think that's a great, I think that's a
And
great.
I like to refer to Delaware law and its former tighter guardrails
Yes,
as a board member than letting this place run amok,
yes.
you know, because I'm truly independent and want to do the right thing.
I think that's a great point, and I've been a board member myself, and I think that Delaware law has an important role in helping the board to do a good job, and to maintain a good process, which is important. If you're in Nevada, then it's going to be much more difficult to do a good job, and because there is no, you don't have to keep the process. The business judgment rule applies to most of the decisions, and it's going to be much more difficult to.
Yeah, last question.
Okay, can I say
Any comment
say
on
one
the
thing?
Dropbox case and the unconstitutionality of
We have just one more minute.
I'll tell you after.
the bigger question?
So I was I want to refer to Michal's point about companies in Nevada and sort of opt-in back into Delaware because there's some nostalgia. And I remember in the aftermath of the opt-in feature being killed on the floor, there was some chatter about what if some companies want to show their virtues and they want to opt out and go back to the old, to the pre-SB 21 rules. And I wonder, well, there's the academic debate, but I wonder if some clients on the shareholder side of companies front, from the practitioner, whether there's been some chatter to try to sort of bond more with the old rules and opt out of SB 21 to go back to the Match.com rules. I know that it's hard probably for 220, but not for
I guess I want to make sure I understand the question. Could you try one more time?
Yes. Is it possible to go back to the rule as it were, to the rules as they were before SB 21?
reverse
If
this.
I go
With 21, other clients that are interested in opting out.
I don't think there's any legal impediment to doing it. If it is true that stockholders en masse believe that SB 21 is value destructive, then you should think that you would see that. I don't think you will, because I don't think they do think that. And I do think that while the matter is entirely up for debate, there are some objective facts that say a pendulum swing isn't a bad idea right now. I say this, and it's a little orthogonal to your question, but I think the answer to your question is a company in its corporate governance documents could do whatever it pleased along those lines. So I think one could achieve that on a bespoke basis. I don't think people will. It is notable what happened in the Tesla reincorporation situation. That doesn't say that Fidelity and Vanguard are going to be on the barricades looking to undo SB 21 on a company by company basis. Worth noting is the astonishing increase in D&O premiums for companies over the past 10 years, especially over the past 5, a radical acceleration of those costs. No one should be pleased about those costs except insurance companies. I raise them in this context because just as when you see that either you can't get insurance for wildfire or flood, or the premiums are out of control, you know something's wrong with that ecosystem. This is some completely objective evidence that maybe it's time for revisiting of what's happening in this ecosystem. And it's a further reason I don't think a firm is going to look on a bespoke basis to create an opportunity for greater D&O risk, because it's going to pay for it one way or another, either through a judgment or a premium or both.
So the one follow-up I have is that I would hope, I'm not sure I would expect, but I would hope that the institutional investor community going forward would require that when a controlled company goes public in Delaware, that the charter requires a vote of a majority of the non-controlling shareholders to reincorporate outside of Delaware.
All right.
And
Let's get the last word.
Well, I appreciate that. To your question, sir, I'm filing my own complaint. It's blatantly unconstitutional. So first, and then second, also to your point, and I'll talk about Tesla with you separately because it was a coerced vote. But on the second point, my biggest concern here is that the gatekeepers are neutered. You're an independent director and you're trying to do the right thing. And you're sitting there with your advisors from very big respected law firms. And you want to say to this controlling shareholder, no, you can't do that. Look at my counsel, and they will tell you that I'm right about this, okay? This is Davis Polk, this is Wachtell. Like, these people know. And Davis Polk and Wachtell will say nothing, because you're no longer supported by your advisors, because it's no longer true.
Please join me in thanking our panel.